Look at these 3 words written larger than the rest, with a special pride never written before or since. Tall words proudly saying, "We the people."
Welcome to the Lex Rex Institute podcast. I'm your host, David Truschel, the lead writer for the Lex Rex Institute.
How does it feel to no longer be one of we the people, David?
I'm still a citizen. Say your lines.
But you're subject to the jurisdiction of a foreign sovereign.
We'll get to that later. Just say your lines.
All right. We got to be careful this week because David, as we know, no longer has rights being stuck in the United Kingdom. So we'll be careful not to say anything too controversial this episode. But anyway, where was I? Oh, that's right. I'm your co-host, Alexander Haberbush, still in America, president of the Lex Rex Institute and also a constitutional attorney, although I won't be speaking in that capacity today, or as David's mentioned in the past, ever on this podcast.
Yeah, I do want to point out, when you lost your place, you were at the very beginning of your part. Anyway.
Yes, that's why I was able to find it again so quickly.
Quickly is one word for it. Probably not the one I would choose. Before we begin, please note that nothing in this podcast constitutes legal advice, and all the opinions expressed are the opinions of the individuals expressing them, not necessarily the opinions of the Lex Rex Institute.
The Lex Rex Institute is a nonprofit constitutional advocacy organization. If you'd like to learn a bit more about our organization's activities or make a donation, please visit our website, lexrex.org. That's LEXREX.org.
And as a reminder, this podcast is a legal issues podcast, not a political issues podcast, notwithstanding what my co-host just said about our special allies across the pond. We try to keep our
Well, that's a legal matter.
We try to keep our commentary.
That's not a political. That's not political at all. You are subject to a foreign sovereign.
Yeah, but the notion that they don't have rights is a fairly loaded.
We did an episode on that, David.
Anyway.
That's our 4th of July episode.
We try to keep our commentary strictly to legal issues, and now that more issues are considered political than ever before, it's important to bear that distinction in mind and even to emphasize it.
Even things like whether the English have rights is apparently political.
Not just the English. There's more than the English over here. But anyway.
That's true, the British.
Yep.
So, in case you hadn't figured it out yet, David is now in Scotland. He'll be studying at the University of Edinburgh and learning all about, well, what's the precise name of your degree, David?
Currently, I am doing, you said last week that it was a doctoral degree. It's not yet. I'm hoping to stay on and do that, but at the moment, I'm in a master's degree in theology and history.
I thought you already had one.
I do have a master's degree, but that was a while ago, and I'm trying to get back into the academic game. So.
Wasn't it also in theology and history?
No. I'm going to cut a lot of this. This is very boring for the people. My previous degree was technically Master of Arts in Religion with a focus on theology.
Oh, that sounds very similar to me.
Similar.
Right?
This one is more historically oriented.
Okay. All right. Well, that makes sense. Studying in historic Edinburgh. Area looks gorgeous.
It is a very pretty city. I will give it that. I have not seen everything over here, but I have been walking all around the city, and it's pretty beautiful, I have to say.
So David's now 9 hours ahead of me. We got to really make time to record this. So you guys should be thankful for this podcast. I hear they call Edinburgh the Athens of the North. Is there any truth to that?
I haven't heard anyone say that, but then again, I've basically...
Well, Wikipedia says
okay.
it, so you know it's true.
Then again, I've basically never heard anyone use one of the supposed nicknames of a city when they're actually there. Like, no one in New York is going to say it's the Big Apple. No one in Chicago is going to talk about the Windy City, etc. So,
no one in Long Beach is going to say it's the best city on earth?
Well, you say that constantly, so that's wrong.
Oh, but people outside Long Beach, I guess, don't really say
No, people outside Long Beach rarely say that Long Beach is the best city in the world.
It's a well-kept secret. Don't come here, please. We have enough people and prices are high enough.
All right. Anyway.
All right, so we got a few interesting topics planned for you guys today. One of them, very apropos, given David's current geographical orientation, actually the same subject as our Ask an Attorney segment that came out last Friday, is going to be the United Kingdom and its laws of succession.
Yeah.
So Charles is king.
Charles is
king.
The
Queen is dead. Long live the king.
And there's going to be a bank holiday on Monday here in the UK with everything, including the university, shut down. And, you know...
Do you think he'll abolish Parliament like the first Charles
I don't
did?
expect him to, although we'll have to wait and see what sort of king he is like. I'm not sure they would let him get away with that again, much like they didn't let the previous Charles get away with it ultimately. But yeah.
No, they really don't.
It is interesting.
Oh, just a second.
Yeah, I had a feeling you were going to do that. They did not guillotine Charles.
No. but he did end his reign 10 inches shorter than he began.
Yes, that is true. You know, a lot of the pageantry around the Queen's funeral and the succession has been taking place here in Edinburgh. It's actually kind of inconvenienced me personally on a few occasions, which, you know.
One of the palaces is there.
Yeah,
right?
Holyrood or Holyrood. I'm not actually sure which is the correct pronunciation.
Hollywood, really.
Not quite Hollywood, but there's a segment of the city called the Royal Mile, which is sort of right in the center. Happens to be right where the Divinity School building is, and so all of the traffic changes and the street shutdowns have actually really inconvenienced me quite a lot. So, you know, due respect to Elizabeth II, but I really wish they had picked a different location to do all this, personally.
Do you think that your education will change substantially given that there's a new head of the church?
You know, the Divinity School at Edinburgh is not affiliated any longer with the Church of Scotland in an official capacity. So,
really?
Yeah, they do
that.
provide training for Church of Scotland ministers, but it's not officially attached. So probably not. Actually, one of the other students who I've met recently at the Divinity School went to pay his respects to...
Whom you've met?
Oh, thank you. Whom I met. Went to pay his respects to Elizabeth II and waited in line for 5 hours to do so.
Oh my God.
Yeah, only to find out...
She was a well-liked monarch.
She was.
She was a very well-liked monarch.
Only to find out, though, apparently at the end, people who got there early were only in line for 15 minutes. So,
Ooh.
Yeah.
Boy, that's
quite
nation
a time
of shopkeepers
commitment.
indeed. People who get there early. So
Yeah. Anyway, but we were talking about Succession, and actually, I found out...
The hit HBO TV show.
No, not that, although I do like that show.
Good show. Its language is not great, but it's a well-scripted show, apart from all of the swearing.
Yeah. Anyway, I think we may have mentioned, and you probably mentioned this in the video, which I have not yet seen, but you probably brought up the Act of Settlement.
I did, yes.
I found out recently when I was prepping for this episode that actually the succession law was modified quite recently, 2013.
Yeah, so in filming that, I foolishly relied on my Blackstone for how it would work because I'm a good American. When I look at English law, I look back to what it was like in the 1750s because I don't really care about the changes since then. They're not really relevant for American purposes. So, yeah, I found out about that afterward as well.
Yeah. We'll get into that in a second, though. So before we do that, we should probably just recap what the Act of Settlement is and what it did.
So it's part of the Glorious Revolution. I guess it's a little bit after the rest of the Glorious Revolution, since that was 1689.
Yep.
88?
I think 89. 89 sounds right to me.
Yeah, so James II, not a real popular guy, probably even less popular than Charles I, but it's a little bit embarrassing to cut off more than one monarch's head. So rather than going that route, the British people decided that they were going to basically declare that his reign was null and void, and they were going to go to the next legitimate heir, which happened to be Mary, who was married at the time to William of Orange.
Yeah.
So they basically cooperate with them to have a peaceful coup. I mean, coup is kind of the pejorative way of putting it. I don't think that's entirely accurate. But a peaceful transfer of power from James to William and Mary. And they codify this with several documents which become part of the British Constitution. One of those is the English Bill of Rights. That's a very significant document. We talk about it a lot on this podcast. But a few years later, when it looks like we're going to have to prepare for the next monarch, so then a few years later, after Mary had died, who, remember, was the one whose claim was actually valid for this transfer of power, and only William was still alive, but I guess it's pretty late in his life, about a year before his death, Parliament figures, we've got to figure out this succession thing. Who's going to be next? So they look back to, I think, the Electress Sophia, right? Because I think she's the one from whose claim Mary's claim was derived, if I'm not mistaken. And they settle her as sort of, we determine legitimacy from her because we can trace William the Conqueror's line down through her. We know that her claim is good. That's the claim that Mary's claim was based upon. So future claims are going to be derivative of her claim. Remember, if you watched our video from last Friday, when figuring out who a successor is going to be, you don't just look back one generation and say like, oh, well, it's the king's brother or whatever. You go back to the original sovereign, and then you trace down the line of, who would inherit at each possible stage, and then you find out who has the second best claim.
Yeah.
After the sovereign who just died. That's when sovereigns have no issue, when they don't have any kids. That's how you figure it out. So what the Electoral Settlement does is it sets the determination of that as stemming from Electress Sophia, as well as introducing a number of other, probably much more interesting, much less difficult to explain things that the presumptive heir of Britain must have. And David, what are those things?
Well, number one most famous is that they must be personally a Protestant.
Must be a Protestant. No more Roman Catholic monarchs, because James II was a Roman Catholic, right?
Yeah. Mm-hmm.
Yeah, they don't want that again.
Yeah.
Now, why don't they want a Catholic monarch?
In large part...
They're just racist? Or...
I don't think Catholics are race, but, bigoted, you could say, or, prejudiced against Catholics, whatever it is.
Is that it? That's all it is? Just a bunch of bigots? Nation
No,
of bigots?
I don't think that's quite fair. One thing is that the monarch of England is necessarily also the head of the Church of England and the Church of Scotland.
Yeah, which is a Protestant church.
Yeah.
Right? It doesn't make a lot of sense to have a Roman Catholic who owes fealty to the Pope being head of the Church of England. That's a good non-bigoted reason.
I do think that there is an element of them just sort of being tired of the Stuarts.
Yeah, I think that's a big part of it.
And, the Stuarts love to at least flirt with Catholicism, if not actually outright become Catholics.
Literally in one case, because Charles I had a Roman Catholic wife. So
and that's another element that disqualifies you is if you marry a Catholic.
Yeah.
And beyond that, I think the only other provision was that it would just, codify that basically the nearest Protestant claimant with a preference for the males would inherit. I don't remember if there were other specific details of the Act of Settlement.
Yeah.
But
so it's, Britain has male preference primogeniture, but it does, so if there are no sons, if a king has no sons, the crown pretty much always in Great Britain would fall to one of his daughters before you would go and do that look back to William the Conqueror and figure out who the next closest heir was. That's not true in every nation.
Oh, and
pretty much every nation has some circumstances where women can inherit the throne, but those circumstances, I would say, are among the more, or were, because they've changed now, but were already among the more liberal in Great Britain. Certainly more liberal than in Game of Thrones, I would say.
Yeah. One other thing I just did remember was that it also imposed a requirement for people in the sort of near line of succession, or actually not even near line of succession, quite broad line of succession, required the permission of the monarch to marry. That's another element of the...
Yeah, and that's still on the books, isn't it?
Well, and here's where we can start talking about the...
So that was the whole thing with, the now King Charles with Camilla.
Yes.
Because I guess that he always liked Camilla, but she was viewed as unsuitable for a prince, so...
Yeah, well, and,
I'm not going to repeat all the history on that. That kind of gets into soap opera. So.
Issues of royal marriage, Edward who was he, the 7th last century? I think he was the 7th.
Oh, yeah. I think that's the 7th.
Yeah, I think it was Edward the 7th.
The one that wanted to marry the American divorcee?
Yes, and that caused a whole mess. He ended up abdicating to George VI, whose daughter, Elizabeth, became Elizabeth II. But anyway, a lot actually changed in 2013 with a new act that they passed, which...
Because remember, this is an important point. Britain is a parliamentary tyranny.
Yeah.
That's literally true. That's legally the case in Great Britain. Parliament can do whatever the heck they want. Parliament can supersede the English Constitution. A judge cannot hold Parliament to the English Constitution. They're a parliamentary tyranny. So because the king acts basically at Parliament's pleasure, and because the whole existence of the monarchy is essentially just a condescension of Parliament to even allow that, they can define laws of succession as well. And Blackstone does acknowledge this. You go back to 1750, Blackstone in his section on this does acknowledge that Parliament can modify the laws of succession. But, I just want to, for our listeners, I want to remind you guys that this is the only country with rights.
Well, anyway, all that being said, so the 2013 act was called the Succession to the Crown Act. And it, is related to an agreement among all the Commonwealth countries that was called the Perth Agreement. It had to do with, in their eyes, updating or modernizing the rules of succession. So among other things, for any claimant to the throne, anyone in the line of succession who was born after 2011, gender will no longer play a role at all. So basically, it's unlikely that rule will affect the next successor to the throne, because there are, plenty of adult offspring of the royal family who are...
William's probably going to be next, and I think Harry's after that, so...
Well, no, because William has a son.
No, I'm saying if William... Wait, is British throne... I'm forgetting, is British succession, is it per stirpes or per capita? If William dies, does it go to Harry or does it go to William's kids?
I think it goes to William's kids, but I could be
I think
wrong
you're
about
right.
that.
I think you're right. That's per stirpe. There's right of representation at each level. You're right. Actually, I know you're right. I remember now.
All right. So anyway, it's likely that the next...
We just did that on our podcast, or on our Ask an Attorney. I addressed that exact issue.
Okay.
Look, this doesn't come up a lot in American law, folks.
Yeah, no, understandably. So anyway, that's unlikely to affect the next succession, but the one after that will likely be essentially gender blind. So, you could call it absolute primogeniture. So, just oldest child.
It's kind of an odd choice.
Historically or philosophically?
Well, it kind of virtually guarantees new dynasties.
Yeah, no, that's fair, but...
Which is, you generally don't want that. For the sake of stability of a kingdom, you want to make sure you have long dynasties.
I get the sense that very few people think in dynastic terms anymore, but...
Well, Game of Thrones is changing that, David.
So are you suggesting that we may see a revival in sort of royalist politics in Europe because of Game of Thrones?
Yeah, I hope not.
That would be interesting. I will give you that. Other things that the act did...
they're probably just trying to be nice to the ladies, too, not sexist.
I assume that, that's the thinking is just that they don't want to have any element of sex discrimination.
I read enough history. My thought is, that substantially limits the women who can be married to other sovereigns to gain political power. It increases your chances of being taken over by a foreign nation through marriage. But I think most of that stuff doesn't really matter anymore. So.
Not much. As we have commented on before, Parliament really does run almost the entire show.
Yeah, parliamentary tyranny over there. But the advantage to that, I guess, is that you can make your line of British succession less sexist.
Yeah. Another thing that the act did...
there's trade-offs, pros and cons to legislative tyranny. We'll let the audience weigh them. That's a political question.
Yeah.
That's the sort of politics we don't get into.
Another thing it did, though, is remove the prohibition on people married to Catholics from inheriting. It still leaves in place the requirement that the actual monarch be Protestant, but they are now going to be permitted to be married to Catholics.
Wait, they don't need pre-approval from the monarch to get married now?
Well, that's the other thing. Only the six, the six closest to the line of succession will still require the permission of the monarch to marry.
Because I don't know how you can't get rid of the requirement that they are disallowed from marrying Roman Catholics if the monarch still has to pre-approve the marriage, because the monarch is the head of the Church of England, and as head of Church of England is duty-bound not to approve marriages to Roman Catholics.
That is probably a more specific question of ecclesiastical politics and ecclesiastical law. And
That's
I don't
true.
actually
know. So this
know.
is just the civil law. Fair point.
Yeah, but at any rate, only these six...
By the way, I'm not saying I approve of any of this. I
Yeah.
think that it's fine if Protestants want to marry Catholics, vice versa. I'm just speaking historically from... People are going to hear what I say, and they're going to say, he doesn't think Roman Catholics should marry Protestants, and that's not true. So.
No, but it is, historically speaking, this would have been a very big issue, but it's an interesting facet of the law that, and actually, this is the last thing I wanted to say about that 2013 Act. It actually does modify the text of the English Bill of Rights. So there you go, folks. There's your legislative tyranny. They actually modified their constitution. It strikes the references to, or is married to a papist, or, et cetera, et cetera. There's language like that.
Does it take all the rights that only pertain to Protestants? Does it modify those?
I don't believe so, no. But
so then it's still only Protestants have a right to keep and bear arms?
I'm guessing they probably modified that one previously as one of the,
So nobody has a right to keep and bear arms.
yeah, numerous
Yeah,
rounds
let's
of
make it fair.
Catholic
Let's make it equal.
emancipation, and then the fact that they severely curtailed that right anyway.
Yeah, that's equal protection of the law. Nobody can have guns.
So, anyway, all that to say, there's actually, and it's, as, speaking as an American, as a citizen of a republic, there's a very weird sort of sense of time that you get when you start talking about, 10 years ago, the English modified the royal succession. It feels very anachronistic, even though it actually is relevant to their current system, albeit in a sort of much watered down version of how it would have been previously. But
so I guess here's the question of the day is, are these new lax standards, are they inviting a new round of wars of religion?
I don't think so. Pretty sure we're not going to see.
Okay, so you're going to take a firm stance on that one then.
I don't think we're likely to see a new 30 Years' War.
What about another English Civil War?
That's probably slightly more likely, but I doubt it's going to be over the issue of the king wants to marry a Catholic.
Of course, at Lex Rex Institute, our preferred method of preventing wars of religion is not to just wait until your society stops caring about religious issues. Our preferred method is to allow for and protect the equal protection of religion.
Guarantee.
And prevent religious tests for office. So something like making a member of our government head of the Church of Tennessee would be something that we don't like.
There's a certain sort of conceptual neatness to that as opposed to just sort of waiting around until no one gets that upset about something anymore. But anyway,
we heard you say something derogatory about the British government. I didn't even get you for a second, David.
Well, for one thing, you're on a video feed. I can see you knocking on your desk. I know it's not someone knocking on my door.
No. So next time I'll have to be more careful about that.
Yeah. Anyway.
They've got those CCTV cameras everywhere.
They do have a lot of CCTV.
Sauron spies are everywhere. You don't know who's listening.
They do have a lot of CCTVs around. I will say that's one thing that they really need to work hard in their police procedurals to get around. Just we have footage of the guy because we have cameras everywhere. I don't know if you watch a lot of British crime shows, but there are a couple that I have watched.
A single one. No, that's not true. I've watched Foyle's War, but that's before the CCTVs, so.
Yeah. There's a one that I've seen a decent amount of called Luther.
Yes.
And
not seen it, but I know of it.
Yeah. They usually need to come up with a reason why the cameras that they've got everywhere don't just solve the problem for them. So.
Yeah.
Anyway.
That's another. So again, we're not weighing the political pros and cons of having rights, but I would say another potential downside of not having rights is that it makes it difficult to write police procedurals.
Yeah. All right. Anyway, that's probably enough on merry old England. And we're going to transition now into American law, where we feel much more at home.
Yeah. Do you feel far from home, David?
Well, I mean, I quite literally am, although not that much further from my hometown than I was when I lived in California. So I guess that there's that. But anyway.
I'm sure it feels further.
Yeah. Anyway, all that being said, we're going to talk now about another case that's on the Supreme Court docket for this upcoming term, Moore v. Harper.
So the court's granted cert in this case, which means that they're going to hear it in the upcoming term. I don't think the merits briefs have been written yet, so...
As far as I know, no.
All we have is the petition for cert, but cert has been granted. Yeah, so David, what's going on in this case?
So to sum up, not get too deep into the nitty-gritty, basically the North Carolina state legislature was drawing up a new electoral map after North Carolina had a seat added to its representation in the House of Reps. And the map was challenged by basically a group of North Carolina Democrats who thought that it was gerrymandered and didn't comply with various requirements for electoral maps. Now,
generally, that's a very common occurrence. When states south of the Mason-Dixon draw new districts, very, very common for there to be challenges, whether it's because those districts are actually racist or whether it's because people perceive them as racist and just like to challenge districts there. I'm not going to weigh in too much on that, but
Yeah.
that's
And,
a common occurrence.
I personally, despite the fact that I was in North Carolina for a few months recently, don't have enough knowledge of its demographics and geography to comment on the merits of the map or the new map. But anyway, so the map was challenged. And
Well, I could say most electoral maps are gerrymandered. Like, so if you were weighing the merits, just like generally speaking, of most electoral maps, you would say, well, this obviously has some kind of partisan agenda. The problem is when that partisan agenda happens to cleave along racial lines, which is not uncommon because for whatever reason, different racial groups in the United States tend to, by and large, vote similarly to their group. So political gerrymandering often looks like racial gerrymandering, hence the challenges.
Yeah. Anyway, the challenge ended up all the way at the highest state court in North Carolina, where they ordered the map to be redrawn, basically on the basis that it didn't comply with requirements under the Voting Act of...
The Voting Rights Act of
Voting
1965
Rights Act,
is what this stuff's heard under.
Yeah, and court ordered it to be redrawn. The state legislature went away, drew a new one, submitted it. That one was also rejected, at which point the court appointed and we'll get into this in a minute, but a special master team to just draw up a new one.
Yeah.
So the state legislature said, we don't think that the court can just sort of, on its own authority, create a map. They challenged that ruling, appealed that to the Supreme Court, and,
saying we've got the authority to do that. There's nothing in the Constitution saying that the Supreme Court of North Carolina can draw lines for districting purposes. That power is reserved to the state legislature, right?
Right, exactly. So I guess the first question, and I'm going to appeal to you here because I really don't know, is what do we make of, in the media they often call this the independent state legislature theory.
Yeah, and they call it a theory, which I think is just such a way of poisoning the well on this. Tell me what you think, David. Let me read you the relevant section of the Constitution here.
Yeah.
This is Article 1, Section 4, Clause 1. What it says is the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof.
Yeah.
But the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators.
Yeah.
What do you think?
Well, so...
Fact or theory?
Yeah, my initial response there is that it sure sounds like it's going out of its way because there are many times in the Constitution where it will just say the states have a power or the states have a right, and it doesn't specify.
And usually that also means the state legislatures because that's coming from a British common law tradition. They were aware that legislative supremacy was a feature of the English Constitution. If they don't specify that they mean somebody besides the legislature, usually it means the legislature. But you're right, there would be some ambiguity if they had just said that.
Right, but they do, the language there does seem to be going out of its way to specify this is a legislative power at the state level. So, at least at first blush, I certainly have a lot of sympathy for this argument. Yeah,
does it say anything about the Supreme Court of that state?
No, although to be fair, not every state organizes their judiciary the same way, so it would be a little odd if it did.
It say anything about the judiciary of that state?
No, it does not.
Does it say anything about a weird quasi-executive appointed by the judiciary of that state?
That it certainly does not say.
No, I don't see anything about that. What I see, and this is pretty telling, because they say it shall be prescribed by the legislature of each state, they've actually got an exception for that.
Yeah.
They have a built-in safeguard, a built-in protection for when the legislature does it wrong.
Yeah.
Right? Because they knew this was an issue. They knew it was a possibility. So what do they say? But the Congress may at any time, by law, make or alter such regulations.
Yeah.
So you've got both the preferred way of doing it and you have the safeguard for when that doesn't work. Those are both built in here. I'm just not sure where there's room for question in that.
Yeah, as far as I've been able to gather, and this is more on the sort of reportage on this issue than anything I've read.
Is that a word?
Reportage? Yeah.
Oh, okay. Go on.
I mean, I think some people pronounce it all French, like reportage, but I'm not going to do that. Yeah, I'm not going to do
Sorry,
that.
Sorry, I corrected you on whom earlier. I'm a little bit of a grammar Nazi, for those of you who don't know.
Anyway.
Grammar National Socialist. No, I'm not. I'm not any kind of socialist. That's not true.
I haven't read any material from lawyers arguing against this position. What I have read is just sort of, commentary from political writers or journalists, what have you. So, who knows if this accurately reflects the legal arguments that have been made prior at lower levels. But the basic argument seems to be, well, yeah, the legislature can do it, but legislatures are traditionally subject to checks and balances under state constitutions. So why wouldn't we just
have
assume...
a check? It says what check and balance we have. It says it right here, David.
Yeah. And, I think this may be...
It's Congress.
Yeah. This may be another instance where, as we're so fond of saying, people just sort of have a fundamental, we would say, mistaken approach to reading the Constitution. Wherein,
like they can't read.
Well, wherein they think that the Constitution is more about setting limits than granting express authority. And
so it's, there's the legislature can do it. Maybe Congress can also do it. But the actual constraints on this system are going to be extrinsic to the Constitution, is what you're saying.
Yeah, basically. Whereas I think we would look at it and say, no, the only way that we know how to do elections is what the Constitution says, and it says exactly this, nothing else than this.
Yeah. And actually what, I'm making kind of light of it, but actually what we're seeing here play out is what I think is an inherent conflict between the Voter Rights Act and the Constitution of the United States, which has been playing out really since the Voter Rights Act was passed. But I think that it's most poignant here, really. So let's sort of take a brief overview of the way that election law works. If you believe that there is discriminatory districting, if you believe that districting, let's just use race because I think race is the easiest to show.
Yeah.
The court has said that political gerrymandering is acceptable. That gets rational basis review. So if you can show that, no, we weren't discriminating against this particular race, we just didn't want Democrats to win. Yeah. That would be okay. You can do that. Might shock people. But again, that's consistent with the Constitution. State legislatures are supposed to be drawing these districts. But regardless, there are two ways you can approach a discrimination case. Well, really, there's more than one kind of voter rights act or voter rights case as well. You can have vote dilution, so that votes of a particular group are being diluted. Maybe they were put into a group they shouldn't have been put into because of how you drew the districts. Yeah, I'm sure you guys have probably seen that chart before, where you have 8 districts, a bunch of different groups of people. You might have 40% Group A and 60% Group B. Well, you can draw the lines in such a way where all 8 of those districts are going to go to Group B. Was the one I said with 60, right?
I think so, yeah. But Group B. You get the point.
Yeah, you guys have probably seen that before. It's possible to do. That would be vote dilution. That's not what's going on here. Here they're actually alleging discrimination. So I'm just going to talk about that. But when you bring a discrimination election law claim, 2 different ways you can do it. You can do it under the 14th Amendment's Equal Protection Clause, which says that equal protection of the laws can't be denied to people on the basis of different protected classes, one of which is race. And then you can do it under the Voter Rights Act. Now, the Voter Rights Act is going to be a lot more permissive in terms of, that's a bad way of phrasing it. It's a lot more restrictive in terms of what a state can do and a lot more permissive in terms of what lawsuits are going to be successful.
Yeah.
Saying that there was discrimination under the Voter Rights Act. So that's traditionally been the way, usually they'll bring both claims, but usually they'll be a lot more likely to succeed on the Voter Rights Act claims. So that's the way these claims work. Originally, under the Voter Rights Act, it was a lot broader than that. Specifically, that Section 5 of the Voter Rights Act required pre-clearance by the United States Attorney General for certain discriminations that were deemed to have a past history of racial discrimination. So that was basically most of the South. All the states that seceded back in the 1860s were basically subject to pre-clearance by the Attorney General. What that meant is that they could not make any change to their own election laws unless the Attorney General looked at those laws first and said that they were okay.
Yeah.
David, does that sound consistent with the clause of the Constitution I read earlier?
No. And, arguably, I'm not sure how this would devolve on states, but it certainly feels of a kind with violations of the 14th Amendment.
Yeah.
Well,
and it's also, even if you were to argue it was consistent with Article 1, Section 4, Clause 1, the way that it would be consistent is that Congress has passed a law that created an agent of the executive that's supposed to pre-clear changes to voting laws in those states. So arguably, it's a violation of separation of powers, too.
Yeah.
Because as we talked about before, non-delegation doctrine says that Congress can't just assign away their powers to somebody else, which is what they would be doing there. That is understandably found unconstitutional. But I say that to sort of illustrate that the Voter Rights Act really had a scheme for controlling voting in this country that, I try not to be hyperbolic in what I say, but it's frankly is directly at odds with the one that's laid out in the Constitution.
Yeah.
So that's the conflict you're seeing here. These claims are brought under the Voter Rights Act. Voter Rights Act obviously gives judges the ability to decide whether or not districting is correct, which is what the judge had decided in North Carolina. What remedy can a judge possibly impose if the state legislature keeps doing it wrong? Pretty much all they can do is appoint their own agent to draw district lines himself.
Yeah. Well, and that brings us to the other thing that I thought would be, of particular interest, because it's in the news for other reasons as well recently in terms of the whole Mar-a-Lago investigation, but this concept of a special master, which is, sort of an odd phrase and one that, I personally had not heard very often, at least before the last few weeks. And so I wanted to get into that. So what exactly is a special master, and under what circumstances are they appointed?
That's a great question, David. What's your research on this, say?
Very little beyond it's something that judges sometimes do to ensure that their orders are executed, basically. Which
that's basically right.
Makes it sound as though
that's I don't know. There is a real strict idea of what is a special master under our law. It's basically sometimes the court will issue injunctions, orders that require somebody to do something that needs somebody to administer those orders because they're not just self-executing.
Yeah.
And judges obviously can't do that themselves. They're judges. They don't go out and supervise things. They're not trustees. So special master is basically a trustee of the court that executes or ensures that the court's orders are executed properly.
Yeah.
That's basically what it is.
Yeah. I mean, honestly, the biggest thing to me is that the phrase just strikes me as so odd when I struggle to see how this is much different than like someone being, the executor of an estate or, basically any other sort of position where you might just sort of be assigned responsibility for something.
Yeah, I don't know the history on that. I don't know why they don't just call him a trustee.
Yeah. Anyway, so
because they are a trustee. That's what their job is, essentially.
And in this case, I think it's noteworthy in the, specifically in the context of Moore v. Harper, that for all that the sort of opposition here seems to want to point to, we're supposed to work within a system with checks and balances, and the way that works is with the judiciary and the executive and the legislative. We talked already about why the Constitution provides for a specific other check already, but it's noteworthy here that the executive part is being done by the judiciary anyway.
Yeah.
There's an ad hoc executive. It'd be, I think, a stronger case on that argument, although not a strong case.
Executor might be even a better comparison than trustee, frankly. They can't call him an executor because then it's clear that he shouldn't be from the judiciary.
But I do think that the other argument would at least sort of seem to cohere better if they had entrusted it to like the governor to oversee the redrawing as opposed to
I think that would still probably be at odds with the Constitution.
I think so too
on this, but
yeah,
that would be more of a check and a balance, certainly.
Yeah,
it's David, look at this book that's in front of me. This is one of my 4-volume sets on the Constitution of the United States. It's called the Founders Constitution. Basically what it does is it organizes the Constitution by clause and then finds all the different things founders had to say about that clause and all their different writings and speeches, so on and so forth, collects them all together. Pretty big pages, right, David?
Yep.
Small text, big pages.
Yep. Double column.
You know how many pages there are on this clause?
Oh, I have no idea.
33 pages,
okay.
Just on this clause.
That's a lot.
33 straight pages. And consistently, across the board, every single person that talks about this is well aware of the fact that drawing district lines can potentially be biased.
Yeah.
That is the point up for debate here. That's the reason they build in the check of having Congress be able to override that law when they want to.
Yeah.
Now, where people disagree, now you have people who are on the more anti-federalist side of things. They're afraid of the idea that it's the federal government that's the main check on this. Now you have people who are on maybe the other side of things that dislike that is given to the state legislature exclusively, the original power to do this. Now, that's sort of the debate that goes on this. Nobody in this debate thinks for a second that districting isn't going to be a contentious issue and that there isn't potential for bias on it. This is not something the founders were unaware of.
Yeah.
That's the reason why, and ultimately they do settle on that check of having Congress be the one to check that, which I think makes sense, especially with congressional districts, because even though those are elected by the people of the state, they are ultimately federal offices. So I think it makes sense there is some federal check on that. That's the system they implemented.
Yeah.
It has a built-in protection. It's the exact protection the framers intended to put there. It's a result of compromise between competing interests. If we go with a different check on that, we are fundamentally altering the scheme the founders put in place and of which they were fully cognizant and aware. So I don't think it's an independent state legislature theory. I think it's an independent state legislature fact.
Yeah. It is, you mentioned that everyone was aware districting would be a major sort of bone of contention.
It's gotta be.
Yeah, and that's true in English history. The phenomenon that you may remember hearing about in high school called rotten boroughs, which were basically these parliamentary districts that
or a pocket borough.
Yeah, that were either they were once populous and now basically abandoned, but they still get representation in parliament, or a pocket borough, being basically just a hand-picked sort of constituency that you can control the outcomes of.
And our system controls for that because it requires proportionality.
Yeah.
Their system does not require proportion. We have one man, one vote, or one person, one vote in this country.
Yeah.
So you can't have one person per district. You got to have roughly the same number.
Yeah.
We do protect against that.
Yeah, but it's, as I mentioned, I've been doing a lot of walking lately because I don't have a car here. And I've been listening to an audiobook about the sort of last decades or so of the Roman Republic called The Storm Before the Storm.
Say the name of the book?
I remembered this time. It's
called.
I'm
sorry, I interrupted the name of the book.
It's called The Storm Before the Storm. And it's not very scholarly. It's, it's very narrative. It's easy listening, basically. But something that I found striking was that same basic issue was really the definitive issue of late Republican politics for the Romans, how to deal with integrating the other Italian people into the Roman Republic. They called them allies for a very long time because they hadn't been these sort of original citizens of Rome. But, as time went on and their society got more and more integrated with Rome, people said, why don't we just make them citizens? But a huge fight ensued over how you would group them for voting, because the Romans voted in blocks that they called tribes. So some people were like, well, let's just put them all into a few tribes and they'll vote last so that the issue is probably already resolved before they come up. And
which is its own whole issue. I mean, the way that Roman voting worked is very counterintuitive if you don't already understand it. But that's actually, that would be a good topic to talk about in the future.
Yeah. But, and, so that was one side of it. And then other people were like, no, we need to disperse them throughout so that they get proportionate representation. So anyway, all this to say, how you draw the rules and the areas for voting is an extremely old issue. And it has always been a hard one to resolve.
And I'm sure that our listeners, we probably got listeners who are listening in and will think, what we're doing now is a pretty bad system. What do you mean state legislatures can just draw these lines and they can do it on partisan grounds? They can make sure that their party is more likely to win. That seems ridiculous.
Yeah.
Show me a better way.
Yeah, it's such a hard problem to deal with.
There's no way to do this objectively.
Yeah.
And I know that our Summer of the Revolution series is over, but there are people who have tried to do it objectively.
Yeah.
The way they did that in France was they just drew squares.
Yep.
And their districts were little squares, and it didn't matter where the lines of those squares fell. If you were in one square, you were in one district. If you were outside that square, you were in a different one.
Yep.
That's a horrible system. It's a really horrible system. It's not proportional. It has no representation of regional interests whatsoever. So if people from place A differ from place B and you cut it in half, it doesn't account for that at all. There needs to be a human element in districting.
Yeah.
By making that a direct political issue, a partisan issue, which is what you do when you assign it to the legislative branch, because remember, that's the political branch of government.
Yeah.
So by intentionally making that a political issue, I think that our founders were very, very wise.
Yeah, because
they say this is the sort of thing where there should be give and take.
Yeah.
People should fight over this. You should come to a compromise in what you're districting is.
You make it an open issue that people can struggle over. It puts it out there instead of making it all backroom clandestine stuff. And I think that is the best solution that we've got to what is a very difficult problem.
Yeah, I mean, maybe someday somebody brilliant will come up with something better. Yeah. But there is currently nothing better that has ever been tried.
Yeah.
It's not an ideal system. Our Constitution does not create an ideal system of government. An ideal system of government doesn't exist this side of the millennium.
I'm not sure people will get that reference, but...
Oh, it's from Blackstone. But...
Oh, interesting. Okay.
Anyway, it's pre-perfection. Yeah. There is no ideal system of government. You're not going to implement a perfect set of rules anywhere, ever. What you can get is a more perfect union, which is what our Constitution does. And if somebody out there someday comes up with a better way of districting, by all means, that's something that maybe we'd want to implement. But there are not currently any. I can say that with a great deal of confidence. Ours is the very best bad system of districting.
Yeah. Anyway, we are a little pressed for time, so I think we should probably call it there and transition into our final segment, if you've got that music queued up.
Gather round, boys and girls, young and old, everybody interested in the eccentricities and crazy world of law in the United States and in Britain now. It's Captain Kangaroo Court. All right, so, David, what kind of stuff do we have today?
Well, we're going to start... I think you'll find this pretty good because I think the vocabulary in question will appeal to you, but let's just read the headline. Lawyer who exclaimed "Gadzooks" at trial delayed but didn't disrupt justice, Ethics Hearing Board says.
What? They brought an ethical complaint against him for saying "Gadzooks"?
Yes. So basically...
What was the context?
Basically, what happened was this guy...
What state is this?
Illinois.
Illinois.
Yeah.
Okay.
So this guy, was in a courtroom, apparently having some friction with the judge. He, kept saying, I'd like to make a record. And the judge was getting impatient and said, be quiet. And eventually said, sit down. And he said, all right, I'm sitting. I'd still like to make a record. And, they have this whole back and forth. And eventually, apparently, he sort of mumbles to himself, Gadzooks. And the judge asks him, what did you say? And he says, oh, Gadzooks. And she told him she was holding him in contempt. And it kept escalating from there.
Oh, that's almost a scene from My Cousin Vinny.
Mr. Gambini, are you mocking me with that outfit?
Mocking you? No, I'm not mocking you, Judge.
Then explain that outfit.
I bought a suit. You've seen it. Now it's covered in mud. This town doesn't have a 1-hour cleaners, so I had to buy a new suit. Except that the only store you could buy a new suit in has got the flu. You get that? The whole store got the flu. So I had to get this in a secondhand store. So it's either wear the leather jacket, which I know you hate, or this. So I wore this ridiculous thing for you.
You on drugs?
Drugs? No, I don't take drugs.
I don't like your attitude.
What else is new?
I'm holding you in contempt of court.
Oh, there's a surprise.
What'd you say?
What?
What'd you just say?
What'd I say? What?
Yeah, it's very similar.
That's almost a scene, but that's really similar to that scene.
Yeah.
Wow.
So apparently at this point, the judge called for a recess. And, when they came back, it just keeps getting more and more tense and hostile between this attorney and the judge. But this is the part that I found especially appealing.
There's probably no audio of this, huh?
I don't think so.
Transcript.
But
probably not even a transcript because he wanted to make a record and they weren't doing it.
Yeah. During the ethics hearing,
you can't. Generally, you need to have a court reporter present to do that. I don't know if there was one or not. But.
Yeah. I only know what ABA Journal has told me, but this is my favorite part. During the ethics hearing, Demokopoulos, that's the judge, testified she didn't know what Gadzooks meant, but she considered it offensive. And it appeared to be a way to critique or undermine her ruling.
Demokopoulos, that's an interesting name for a judge, isn't it? What does that mean? That means like the people's city or something like that? Or the many's city, yeah.
Something along the, polis for sure is city. My Greek is too rusty to tell you beyond that. But anyway, I do love that idea, though. She hears a weird word, and she assumes it's offensive.
That sounds like a lot of judges I know.
All right. Anyway, do you have one, or should I go on to my other one?
Oh, I have a couple. I didn't prepare them, though, so use your other one.
Okay. All right.
Bring them next week.
Yeah. And this other one, another judge involved, but under very different circumstances. Judge is suspended after he's accused of pointing AR-15 style rifle at stepson.
What's the context of this one, David?
Honestly, the context doesn't make this much better.
It's hard to see how it would.
Basically, so setting aside sort of all the background stuff about the procedural, this is what the judge had to say about it. And so it's Judge Thompson says, the confrontation began after a car drove toward him at high rate of speed while he was walking his dog. Thompson feared for his safety because of, and this is part of the background, as he said he was under a lot of stress because he'd received some threats, I assume, in relation to something that was going on at the court. So Thompson feared for his safety because of the threats he had received, and he reacted angrily when he saw his stepson was a passenger in the car. The stepson appeared to be intoxicated, was confrontational, and insisted on entering Thompson's home, he claimed. And so after that,
I feel like that makes it a little bit better.
It helps a bit, but it's still probably not extremely judge-like behavior.
No,
it's basically
somewhat injudicious.
Yeah,
that's true. I have a great one that I would love to tell. Unfortunately, it's confidential. But I'm let's just say David knows what it is. But I'm working on a new case that's fairly high profile. You'll probably hear about it in the coming weeks. And I'm one of the lawyers who's also working on that. So somebody who's co-counsel with me is a very well-known lawyer. And gosh, I probably shouldn't say much more than that, but it was
probably not.
I had a hilarious phone call yesterday.
Yeah, well, sadly, probably can't really count that as Kangaroo Court.
It's really funny though. Like, guys, it's really funny. You would love it if I told you, but it's confidential and I can't.
Yeah, well, that's a big tease, I guess. But
it was funny, right, David?
It was a good story. Yeah.
Yeah.
It was a good story. Maybe one day.
So just. If you guys didn't like our other things, just know we've got good ones.
We just can't
tell them to you.
We totally have a girlfriend. She just goes to a different school.
Yeah. Just so.
Anyway, but last thing I want to say about this thing, though, with the gun is just that the thing that really makes it for me is that it's a stepson, because I feel like that just speaks so much to the weirdness and awkwardness of the situation. Like, it always seems to be specifically step parents who get into these bizarre situations. And anyway,
that's really not that funny, David. That's more sad.
Okay, well, if you want me to cut that, I will cut that.
I guess to each his own.
To me, it was funny.
No, don't cut it. Anyway, that's all we have for today, folks. Hopefully you guys enjoyed the zany, wacky world of American law. Stories you can be told and the stories that you can't in Captain Kangaroo Court. So we'll see you folks again next week.
All right. Well, as always, thank you for listening, and we hope that you'll listen.
Oh, by the way, David, did you listen to the episode with Eric Hampton in it?
I did, because I edited it, which but...
For the audience's sake.
I did listen to that, yes.
He did a good job, right?
Yeah. I don't know if anyone has actually reached out to you to tell you that they want him to replace me, but if you do feel that way, you can let us know. I'll only be mildly devastated by that.
That's so very sad, David. We're not going to replace you anytime soon. We love you, David. Also, you have much more availability than Eric. So
that's true. I think that's the big advantage.
because David's, he's a writer, so he's on the team doing this kind of stuff already. Plus, the time difference doesn't really help. But
No, the time difference doesn't help, but, academic schedules tend to be at least flexible, if not open.
yeah. So he's still going to be working with us. If you worried that he wouldn't be now that he's in school, David's a hard worker. He'll still be working with us. So, yeah, that's all for today's episode. If you didn't check out the one with Eric last week, go ahead and check that out. Also, if you want to learn more about succession, check out last week's Ask an Attorney video entitled, I don't think we have a title for that at the time of recording, but you should see it. It's the most recent episode at the time this launches, which will be September 19th, 2022. That's all. Thanks for listening, folks.
All right. Goodbye.